Before I like to get a little like a certain amount of drawers or like what?
They have all 12 of them.
Oh,
So if one of them, two of them
doesn't matter.
Ms. Feely, is the monitor on your table on?
It's on.
It's on, but it's not connected?
Oh, yes, it's on, but it's not connected.
Okay. All right. Nah, IT can come make it happen.
Yeah, it's no, I have that.
Okay, they can come deal with it.
You want a podium on?
Podium is good.
Yeah.
Yeah, no, we've got podium and we should have the big screen. And the witness screen is working, which we don't need. And then the camera up there is working, which we also don't need. But I think we can get started. I need it to the big screen so that did that show up on the big screen? Woohoo! All right, that's what I need. Let's get on the record, please. In State versus Hall, it is Thursday, a little after 9 a.m. All our jurors are here. What remains is to charge the jury, and then they can begin their deliberations. I meant to ask both sides to begin thinking about what exhibits don't go back. If any exhibits don't go back, be thinking about that while I'm charging the jury so that right away we can create the universe of exhibits that go back with the jury. They're usually ready to go and there's this odd pause while they're waiting for the evidence. So please be thinking about that. We need that one connected as well as the prosecutor one connected. Please. So we need to figure out what evidence goes back with the jury. Ms. Feely, you have a chance to review the verdict form.
Yes, no objection to that.
No objection. It's consistent with what we discussed last night. The jury charge, you've got the final version in front of you. There were a couple of tweaks. I included in justification the defense of habitation, and I included the one that is the best fit. It's not a particularly good fit, but it's the one that you had asked for, the unlawful entry in a violent and tumultuous manner. I also edited reasonable beliefs. I hadn't removed threats, and so I took the word threat out of there. It used to say for the defendant's threats or use of force, the defendant must believe that his threats or use of force, but there were no threats here. It was just use of force. So that's pages 10 and 11. It just talks about use of force. Mr. Abate or anyone else from, here, Mr. Hiles, anything about the jury charge you want to get on the record?
Object to the
Defensive habitation?
yeah, I don't think it applies to any of the facts together in this case.
Okay.
And then, Your Honor, did you email a copy?
I did not. I said I was going to do that last night, but I wasn't able to work on it last night. I can email one. You've got a hard copy in front of you. Would you like an electronic version?
Would you mind doing this?
I don't mind.
And they really think took too much for all reading the same copy.
Well, they already heard about the restroom, so it's all uphill from there. Actually, I'll send you an electronic version too, just so you don't feel left out. All right, Mr. Abate, is there, well, Ms. Feely, did you have any other issues with the jury charge?
No.
Okay, anything, Mr. Abate, before we bring the jurors out? Ms. Feely?
No.
Okay, Mr. Hall, you look good. You got multiple layers on today. Let's bring the jurors out, please.
All right, the jury. I'll do the president of the county for.
Thank you, Deputy Gordon. Let me attach one file real quickly, ladies and gentlemen, and then we'll get started. Did that attach? Great. Okay. Good morning. One of you had an alarm clock issue. I don't know which. It doesn't matter. We're all here. It's good. And we are ready to go. I appreciate you being back here on Thursday. What remains in terms of a presentation from someone here in court to you is my presentation to you on the law that you must apply to the facts as you find them to be. And so for the next 20, 25 minutes, I'll be reading to you the law, a couple things about it. First, format. I'll be reading from this document. You will get this document back there. So feel free to take notes. But point number two, there is some legalese in here. There are some legal terms that I am required by higher courts to define in a certain way. And it chaps me that I need to use this stilted language, but when a court of appeal says you need to do it, I need to do it. So you're going to hear me say something like abandoned and malignant heart. You say, why are you talking like that? I mean, it sounds like a tumor or something. It has nothing to do with that. That's just one way the law defines this concept of malice, which I'll get to in a little bit. I try to make this as accessible as possible because you need to apply it. And so I apologize in advance that some of our higher courts are less into accessible language than I am. I will read this to you. You will have it with you to review. So don't panic if some of the words go flying by. On that big screen right there will be what I am reading. There's not a bouncing ball. It won't be word for word, but each paragraph that I'm going through, you'll be able to see. That helps some folks absorb. So feel free to read. You also, as long as you're awake, can just be a listener, close your eyes. But as I said, this document will be with you. Let me make sure I've got the right screen up. All right. Did it move? Now does it say indictment? All right, we're rolling. All right. A grand jury has indicted the defendant for murder, felony murder, aggravated assault, and possession of a firearm during commission of a felony. The defendant has entered a plea of not guilty to these charges. Neither the indictment nor the plea of not guilty is evidence. And a reminder, it's not on the screen. You'll be getting the indictment. So you'll see the charging language in there and everything that is charged. The defendant is presumed innocent. This presumption remains with him unless it is overcome by the state. Trying to shrink that down. With evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of each crime charged. And I will be giving you the elements of those crimes soon. You're not going to have to divine what the elements of murder are. It's spelled out in the charge. There's no burden of proof upon the defendant, and the burden never shifts to him. If a defense is raised by the evidence, the burden is on the state to disprove or negate that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says, a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror, that's you, honestly seeking the truth. It does not mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. And that reason must arise from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering that evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if such doubt does not exist as the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant a grave suspicion of the crimes charged, or that merely raises a speculation or conjecture about the defendant's guilt, is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law. You are bound by my instructions. That's what's happening right now. It is your responsibility to determine the facts from the evidence that has been presented. You must then apply the law I'm giving you to the facts you find. You must decide this case based only on the evidence presented during trial. That evidence consists of testimony, exhibits, and a stipulation. Evidence does not include the indictment or plea of not guilty, anything said by me or the lawyers, to include their opening and closing remarks, nor any questions posed. And that's a reminder. You may have written down a question and it wasn't asked. Your question wasn't asked. There's no evidentiary conclusion that you should draw. Like, hey, the judge didn't ask my question. It just means it wasn't a legally proper question. Don't assume that the answer would have been yes or no or anything like that. Questions are not evidence. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, such as an eyewitness. I was there at the intersection. The light was red when the car went through it. I could see it. That's an eyewitness. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. Well, I wasn't at the intersection, but I heard screeching tires, the sound of metal. I know there was an accident. You didn't see it, but there is some evidence that you've gathered that makes you think there was an accident. There is no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. The parties have entered into a stipulation about certain facts concerning the ballistics evidence in this case. When parties stipulate facts, you may take those facts as given without the necessity of further proof. You must determine the credibility or believability of the witnesses who testified before you. In deciding this, you may consider the evidence, the witness's manner of testifying, their basis for knowing the things about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their possible bias for or against a party. The credibility of a witness may be attacked by disproving facts to which the witness testified. You may also consider other evidence offered to attack the credibility of witnesses, including evidence of a witness's bias for or against a party. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here in court to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You heard from expert witnesses. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. Testimony of an expert, like that of all witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration is not required, provided you find the witness's testimony to be sufficient. Defendants who have no burden to prove anything are not obligated to testify. When, as in this case, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. Identity is a question for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. But keep in mind that the state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but means simply the intent to do the thing that is in fact illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find that intent, or the absence of it, from considering the words, conduct, demeanor, motive, and other circumstances that are connected with the acts for which the defendant is being prosecuted. Criminal cases must be tried in the county in which the crimes were committed. This is the question of venue. That is, were the alleged crimes committed here in Fulton County? And it must be proved by the state beyond a reasonable doubt. Now we're going to get into the elements of the charged offenses. The first is murder. For murder, the state must prove that the defendant, number one, caused the death of another person. Number two, that he did so unlawfully. And three, that he did so with malice aforethought. That's one of those phrases, but it's in the law, malice aforethought. The killing must have been done with malice for it to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. What it means in this context is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another. You may also find malice when there does not appear to be a significant provocation, and the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, again, that's the unlawful intent, it is a murder, regardless of how briefly that malicious intent existed. No specific length of time is required for malice or unlawful intent to arise in the defendant's mind. That malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act that killed and moved him to do it, that is enough for the killing to be murder. Proof of motive is not essential to the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes the defendant's state of mind at the killing, at the time of the killing. Felony murder, that's count 2. For felony murder, the state must prove that the defendant, number one, caused the death of another person. Number two, by committing a felony. The state does not have to show that the defendant acted with malice, that is, the unlawful intent to kill, to prove felony murder. And I'm telling you now that aggravated assault, which is count 3, is a felony. You may find the defendant guilty of felony murder if you believe that he caused the death of another by committing the felony crime of aggravated assault, regardless of whether he intended the death to occur. There must, however, be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. In considering the malice and felony murder charges in this case, you must decide whether the defendant was sufficiently provoked and acted out of passion. If you find this, you may not return a verdict of guilty of malice or felony murder, but you would be authorized to return a verdict of guilty of voluntary manslaughter. The state must prove beyond a reasonable doubt that the offense should not be reduced from murder to voluntary manslaughter. For voluntary manslaughter, the evidence must show that the defendant, number one, caused the death of another person. Number two, under circumstances that would otherwise be murder. And number three, he acted only because of a sudden, violent, and irresistible passion that resulted from a serious provocation. Number four, which was sufficient to excite that passion in a reasonable person. If you decide that enough time passed between any provocation and the killing for a reasonable person to have cooled off and regained judgment, then the killing is not voluntary manslaughter. Aggravated assault is count 3. A person commits an assault when he commits a violent injury, when he attempts to commit, start over. A person commits an assault when he attempts to commit a violent injury to another. A person commits an aggravated assault when he assaults another with a deadly weapon, and a firearm is a deadly weapon. Count 4 is possession of a firearm during commission of a felony, and that is defined. A person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. It's one of the most self-descriptive statutes we have. Murder, felony murder, and aggravated assault are all felonies. And a firearm, that term includes any handgun. The defendant in this case has raised a defense that even if he committed the acts that are described in the indictment, there were circumstances that justified his conduct. Once this defense of justification is raised, the state must disprove it beyond a reasonable doubt. Sometimes a defendant's use of force is legally justified and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when, number one, he reasonably believes that the use of such force is necessary to, number two, prevent death or serious bodily injury to himself. This is self-defense. A defendant is also justified in using force that is intended or likely to cause death or serious bodily injury when, number one, the other person makes an unlawful entry in a violent and tumultuous manner. Two, the defendant reasonably believes the entry is being made to assault someone in the residence. And three, the defendant also reasonably believes that the use of such force, this is deadly force, is necessary to prevent or stop the assault. That's defensive habitation. If you decide that the defendant's actions were justified, it would be your duty to define him not guilty. A person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. However, a defendant is not justified in using excessive force while acting in self-defense or defensive habitation. If you decide that the defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then the defendant's actions would not be justified. For the defendant's use of force to be justified, number one, the defendant first must believe that his use of force was necessary. Number two, that belief must have been reasonable. That is, a reasonable person would also believe that the use of force was necessary. Number three, the defendant's reasonable belief must be what prompted him to use that force. A defendant is not justified in using force against another person solely in revenge for something the other person said or did on a previous occasion, no matter how serious the past wrong may have been. If you find beyond a reasonable doubt that the defendant used force against the alleged victim for the purpose of avenging a past wrong and not for the purpose of preventing imminent death or serious bodily injury, then you would be authorized to convict the defendant. Ladies and gentlemen, you should consider each count in the indictment individually. The defendant may be found guilty of some, all, or none of the charges. If, after considering the evidence, together with this charge, which is almost done, you should unanimously find, beyond a reasonable doubt, that the defendant did commit here in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty. And you would check that option on the verdict form for that offense. This is your verdict form. We'll get it in a little bit. And for most of the counts, there's the option of not guilty or guilty. And if you unanimously find that the defendant is guilty, you just check guilty. You don't have to write anything else. There are a few extra instructions because of this lesser included of voluntary manslaughter, but it's all self-explanatory in there. If you do not believe the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. And you would check that option on the verdict form for that offense. Whatever your verdict is for a particular count, it must be unanimous, meaning agreed to by all of you. Your verdict must also be in writing, that's this, signed by your foreperson and dated. Ladies and gentlemen, by no ruling or comment that I have made during the trial have I intended to express any opinion about the credibility of the witnesses, the evidence, or the possible guilt of the defendant. Your verdict in this case must be based solely upon your consideration of the evidence according to the laws I have given to you in this charge. It's your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign and complete this verdict to which all of you freely and voluntarily agree. You should begin your deliberations with an open mind, consult with one another, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any research. You have all the evidence in the case. It's enough or it's not enough. That's for you to decide, but you don't get to supplement it. It would be improper for you to supplement it with any outside information. To assist you in complying with this instruction, Deputy Gordon will be collecting all your electronic devices. That includes Apple Watches. If you have Apple Watches, give them up. We'll hold on to them. You'll get them back, I promise. They'll sit in my office. They'll make lots of beeps and whatnot. And when you're done today, you get them back. Going forward, if you need to communicate with me for any reason, we need a break, we want to watch a video again, whatever it is you need, it needs to be in writing. Write it down. You'll get in touch with Deputy Gordon. He'll bring it to me. I will then confer with the lawyers and share with you whatever response I'm allowed by law to give. And I add that little phrase at the end because sometimes you've got a great question and all I'm allowed to say is you have to work that one out. Because I can't weigh in one direction or another. But don't cause that to have you not ask the question. If you've got a question, ask the question. And if I am allowed to answer it, I will. But sometimes the answer is you'll have to rely on your collective recollection, which is me saying you got to sort that one out. But if you need something, we need a ruler, you need to review some of the evidence, that is 100% doable. We'll bring you out here if you need to watch the videos again, and we'll handle it that way. That's it for my instructions to you all. In a moment, I'm going to have 12 of you go back to the jury room. You will get, as I said, the indictment, this jury charge, this verdict form, and the evidence that has been admitted. Two of you, though, need to stay here with me, and those two are Mr. Gorman and Ms. Copeland. The rest of you, if you would please go with Deputy Gordon and start relinquishing your electronic devices. Those are some sparkly boots. You two are our alternate jurors. You have played an important role by hearing all the evidence. And had we needed to excuse a juror because of an illness or family emergency in the middle of the trial, you wouldn't have known, but one of you would have slid into being part of that 12. I'm going to ask you two to stay here today for as long as they deliberate. If we don't reach a verdict today, we can talk about whether you could be nearby tomorrow, but could get here within 30 minutes notice, but we don't need to worry about that today because you're going to stay here today. You get to keep your electronic devices. You can use them. Just don't do any outside research. You stay in that bubble. You two can talk. Don't talk about the case. You don't have to talk. When they break for lunch, you can break for lunch. You can go to lunch with them because they cannot talk about the case outside the jury room. All 12 of them need to be together. And so if people are going to lunch in different places, you'll go with them. And so we'll let you know when they're breaking. You're going to be in another jury room over there, the one that says disaster shelter or whatever it is. It's actually another jury room. It's got restrooms. It's got a table. That's where you two will hang out. We will not forget about you. We're not going to leave for the day and you're knocking, hello. If there is a verdict today, after I receive that verdict, we'll bring you out here as well, so you'll know what happens. But we need to keep you nearby. I may need to excuse someone in 20 minutes, and then one of you is going to join that group, and they'll restart their deliberations. And if I have to excuse two people, then both of you will. But we always have alternates because we never know when we might lose someone, and we don't want to have to restart the trial. So your service has been equally valuable. You're missing out on the deliberations piece. But you'll reunite with them. If we finish today, I'll get all 14 of you in there to sign you out and get you going. So any questions about what's happening next? You can get your stuff from in there if you have things. And again, you keep your electronic devices. Just don't do any research about the case. Okay? Deputy Gordon will get you in there. Mr. Abate, is there anything else from the state? Ms. Feely?
We would just renew our request to charge involuntary felony and involuntary misdemeanor OCGA 1653 subsections A and B, and renew our objection to having not done so, and renew our objection to the revenge jury charge.
Got it. Those are all renewed and protected. Can you all talk about what things, if any, don't go back with the jury? I don't see, oh, the evidence is over there. Work on that, and I will mediate any disputes. Unless you've already sorted out, everything should go back.
I think everything goes back on this one.
Okay, great. And my thought is that we send the videos back, the discs, just so that's a reminder for them. And they could say, we want to watch X or Y or Z. And I'm perfectly comfortable having the firearms go back because they're secured, but I'm going to ask him. Deputy Gordon, we've already sorted out, the lawyers have, that all the evidence goes back with the jury. I'm assuming because the firearms are secured, there's not an issue with that going back, but I'm assuming not deciding. I don't know if you have other directives. Okay, you should check them again, but they've got those like bike lock cables through them. And so my request, unless it's inconsistent with security protocol, would be that everything goes back with the jury. So I'll give you the 3 other documents that need to go with them. You can get that to them. And then I need, from the state, 1 phone number that we can call to get folks back in here. So you just write it on one of those note cards, and then Ms. Feely, if you'd write your phone number. And then I'll get you back here as soon as there is a question or anything else.
You have an objection to waiting for me.
No, you're welcome to stay. I have some stuff on Zoom, late morning and lunchtime. So I'll just be back there. But everyone's welcome to stay. Obviously, Mr. Hall will go back into the holding area, but we'll bring you out whenever there's a question or anything where we're interacting about the case. All right, so we can take Mr. Hall back, and then let's get the evidence and the other paperwork to the jurors, and we'll be underway. No, to me. Thanks.
Wow, that's
All right, the jurors, we're back on the record in State versus Hall. The jurors have submitted 2 more cards. One says, watch interview with Stuckey, and the other says, ring videos. That's all they say. I suspect that means that the jurors want to watch all those things. We're going to bring the 12 jurors out. I will ask them if that is in fact their request and the order in which they want to watch things, ring videos versus the Stuckey interview, and if they really want to watch the entire Stuckey interview. And if they do, we still need to skip over the things that we skipped over before. So I guess we'll navigate that accordingly. Can you get the Stuckey interview teed up to where we started before if they want to watch the whole thing?
I will.
Okay, all right. And do you control that by having to stand in front of the monitor like Mr. Abate is?
When we do it on this, just because the device is better, I will, but I would be able to get up and navigate.
Okay. All right. Do you have any objection, Ms. Feely, to the jurors watching these things again?
Just the same objection to the mention of the buying weed.
Your client saying the word weed.
Yes.
Got
twice.
it.
Thank you.
Noted. Overruled. Anything from the state? Okay, let's bring the jurors out, please.
All right, for the jurors. All jurors are present, the time for.
Thank you, Deputy Gordon. So jurors, I received one card that says, watch interview with Stuckey. And another card simply says ring videos. I'm guessing that means you want to watch the ring videos. It's okay. I too can use my common sense to make deductions and reach conclusions. We can do that, and we will do that. We're going to use the device that's in front of you. It works a little better. No offense, County IT. And the audio is certainly better. Do you have a preference, ring videos first or Stuckey interview first? Okay, we'll see whatever is queued up. Secondly, the Stuckey interview is very long. Was there a particular part you wanted to hear, or you really want to listen from start to finish the Stuckey interview? Sounds like one juror wants to watch the whole thing. Unfortunately, you all have to watch it if one wants to watch it.
Wasn't there a part that we skipped over because it was just a long silence?
We'll skip over that. I've already asked Mr. Hiles or Mr. Abate to skip. In fact, there were certain things that we had to skip over because of rulings I had made. So you're not going to see anything different. I just was curious if really we only want the part when X happened, and you're saying the whole thing. We will go, I don't remember how long it was. We broke it into 2 parts, but how long is that?
We break it into the 2 parts. It's just under an hour.
Okay. There you go. It's what you've asked for. We may have to pause it a little before noon because of something I have to do for about 10 minutes. I wasn't thinking I'd be out here. I figured you'd be back there. But then we'll restart it. And then we can watch the ring videos. I have a couple of immovable Zoom things I have to be on that are all around lunchtime because I figured you'd be having lunch. And so I may decide for you that you're having lunch. Normally you get to decide when that happens, but if we crash into the noon hour, which it looks like we're going to, it may be that you go eat And when you come back, you can watch it 6 more times. I have nothing in the afternoon, but knowing you might be deliberating and knowing you'd have lunch, I put a few things on at noon that I can't get excused from. So without further ado, let's at least get started. So it worked just a moment ago.
Once you start,
Because everything is off county Wi-Fi, so.
Oh,
Works a minute.
I thought this was, you plug directly into this. That was the value of this. You don't have thumb drive plugged into? I thought it was,
We did.
okay,
It's playing off a Wi-Fi speaker.
okay. So that speaker being plugged in, that's for power and not the actual audio feed.
Correct.
So. You hungry, you need to drink. I have Look at your arm, legs.
Can you put the speaker in the middle?
Okay, and even now, you see the little scar? Is that not a scar? Are you okay?
Something like that.
Okay. Can you see the bottom of your shoes? Are these shoes that you had on the entire time? You just have one? Alright. Okay. I spoke to your daughter. Primarily, well, that's not even. So we are able to move Corey. Got in touch with some family, as you saw actually out there on scene, and I think I'd like to get you something to calm you. Can I get you some? Let me get you some. You sure? I don't know everything. I had my daughter, she was a baby, even though I know Corey, dog. I had her, she go play, he just messed his whole life up. And I just love everything. Corey, how long you and Jason were on date? Oh, like 6 years. 6 years. Oh no. Tell about the work dog. I really think we'll be able to, I don't say don't worry about the dog, but I think we'll be able to find that dog. You need to phone number for you. 317-774-791-8810. Now, you gave me actually some more information than I last spoke with you before you left on scene. You told me that the door was shut. So the door was shut. So at some point, Corey left. He shot through the door. But you got Corey out, and the door was shut. And how long was the door shut before? I thought he was gonna kill me. Where were you at the time? I was right there. And you over there,
fast,
yeah,
but. It was a cow, and it was, my ears, that's what I remember.
let me tell you one more hard thing. I think it's gonna be hard, but I want you to know, because I want you to hear something and then relive it over and over again. So, spell it out to me again. O-N-A. Her last name? Got it. S-T-O-T-T. So, well, tell me why you thought she was shy.
For some reason, when I came up, it looked like I seen her scared. I don't want to say. I want to be factual.
Yeah, no, please,
But
take
to
time.
me, like, it wasn't bad, like, I thought it still coming. But, I don't know where they got it from. Because when Corey was in there, he did. Corey did show them. I'm gonna say that, and that's what I got scared of, like Corey. And I pushed him like, Corey, go, I was like, go. And for one, I didn't even want him to come with you. I told my daughter to go. That's what kind of bad thing. I told my daughter that she would leave. She was like, oh, we're not gonna leave you out. I said, I always stand outside. So I brought my dog outside 3 times. She was like, Mom, we're not gonna leave you out here. She sat in the car. He got a car. I said, Corey, I'm okay. He was like, no, I'm walking you upstairs. Literally, I just thought he was walking me upstairs. But when he came in the house, the way he was sitting on the couch. I remember that.
You talking about, Jason sitting on the couch.
He was sitting on that couch, and, he seen him, he was like, what's up? He was like, what's up? He was like, what's up? Like, Corey was like, it's my fault.
No, alright. Oh, you remember how you said, let's stay factual? You remember how you said that? We gotta stay there. You gotta stay there, okay? Let me tell you, if that was true, you'd be locked up right now. Do you understand me? You wouldn't be in this room right now.
It's my fault.
So this is where I'm a little confused. So why do you feel like she came up, your daughter was, if the door was,
No, when I was in, and I don't know if I seen it, maybe I'm just thinking.
and it's no rush, I'm just trying, I believe everything you're saying, it's just, I'm just trying to understand, that's all.
I just trying to understand, no, about that, I look, and just close the door, just let it shoot. You know what I told you? Sure.
Do what he said.
So maybe that's why.
Well, the only reason
When
I,
I opened the door, she shoot, what did you do? He was like, I told him, if don't see the camera, maybe he walked outside. He was like, I told him, he came and said, you should have had a gun, you should have had a gun. And, which I did, but I'm like, you didn't have to do that. I don't know why I just thought about my daughter, but that's what I said.
well,
That's
you
what
just
I
said that you heard her screaming, so in my mind,
I opened the door.
and you heard her screaming. Does that make sense? Okay, so this is what I was gonna say, she got graves, but she's okay. You saw her. She's fine. I just want you to know, because at some point you're gonna hear about it.
Oh my God, no, fuck. Oh my God, I just keep going.
We're gonna get him. Let's just go ahead and knock the hard part out.
Oh, that's him. That is him. Him.
I want you to just put your name, the date of the incident, which is actually 4/30/22. And just something, yeah, this is you right here.
If I could talk to you right now, bro. If I could right now, you told me to go, baby. I told you that. You go, baby, do everything. Everything. That's gonna see. See.
Is your last name Saxon?
Study.
STU?
CKY.
CKEY? What's your date of birth?
March 27,
And you just had a birthday. 1980, right? What's Miss Scott's birthday?
my daughter's, September 17, 2000.
00. Okay, and you're 317-794-8810.
Yeah.
You know Miss Scott offhand?
Four seven, my phone did too. It's 470, I don't know, 7531, that's what it is. I just can't go. That's my son.
Okay. What kind of phone you get? iPhone? We'll get you a charger, okay? When he was walking away, what do you have?
Like I told Lois at first, when she, when I went in there, was coming, he had some blue shorts, I love that. Shorts, white shirt. Some airbags that was like blue and red or something.
Blue red neck.
Does he have?
You told me he may have a family member that's working in senior citizens home. And then there's his
I was
actual,
in my house.
and his actual address is East Point. East Point, okay. All right.
Oh my God, Corey.
Yeah. You know, you
You
got
know
out,
why I think it's my mom? Because he was literally making something.
because he was trying to look out for you. No, I get why, I do. I'm not gonna stop telling you though, it's not your fault. I get why, I empathize and I get your perspective, but I'm still not gonna tell you that it's your fault, because it's not your fault. Did you pull trigger? Were you the one who lost your temper? Were you the one who shot through a door? Did you tell anybody to shoot through a door? Weren't you the one who said, leave? You told him to leave. I'm just telling you, I'm not saying
I just said, but I just put, I see that side for a second. And that's not, I'm looking.
I spoke to a couple of neighbors, they say y'all all the time.
Yeah,
All the time.
but it never got that, he never told me that was me.
I mean, he still hasn't. He still has not pulled out a gun on you. He hasn't shot you. He's going down. He's going down for murder.
You know, everything like that. I don't care, man. Do you have to have all options? Just leave. You don't know those people alone.
I mean,
Next one.
bro,
And I said, I'm just gonna leave myself my brother. You know, the whole conversation. I said, I'm not doing, we argue, but it don't get to that extent because I'm a person that walks out and then go, you know. And I said, I go outside or my dog. And my dog was my person because of my daughter.
I'm just gonna go get you the charger. Can I get you something to drink from out there too? Just take it, okay? If you don't wanna drink it, don't drink it. You can just let me know. Get you the charger. I'll be right back.
you don't mind if I just fast forward while she's out of break?
I appreciate it. Assuming you know how to do it.
Oh, Corey. I just need to give. Sure. He don't need, because you just don't like to try to help this phone up, you go, like, nowhere.
Now, I want you to understand, I'm just being straight up, of course, one of the primary reasons we want to bring you here is because you work there. And, we're gonna keep you here so everything there is completely clear. We got a lot more units out there, it's a lot more calmer, but there's still a lot of people out there. And I want you to know you can be safely here, and I'll make sure you get back there, and we don't even have to keep you. We can take you wherever you wanna go, and
I don't have nobody to go to.
okay, so, let me try to make a phone call. I mean, in situations like this, I can just call this particular person to see what our options are, and you can come up with a decision. But I'm trying to tell you, if you did want to, if you wanted to go, we're not gonna take you back unless everything's safe. And we're not trying to rush that, like, if it takes another hour or two, if there's a more comfortable room, we can let you sit, you can keep, hold on to this charger. If you wanna take a nap, that's fine, but I will be here regardless. I'll make sure you get home safe, okay? How long tonight, when you and Jason arguing, if you remember? Let me give you an idea, let me give you some help about like time. So when we got the 911 call,
It might be 10-15 minutes.
at 11:30. So 10 to 2 minutes before 11:30, so let's, about
Well,
11.
being able, I don't know, we probably gonna lose, it could be a paper on the floor, and I'm mad if you did that, or it could be he shaved his face, and then we don't.
Hey. No, negative. Who all lives with you? I know.
Just my us.
Negative. Correct. Good question. Now, you want us to secure your apartment, or you want us to
Oh, my God.
or do you want us to,
I don't have a.
you have it?
She have a dog?
You got it? Belong. You have the dog? No, it's in your apartment.
My dog?
Your dog's in your apartment. It's Shih Tzu, right? Yeah, it's Shih Tzu.
Oh my God, that's my support dog for my daughter.
It wasn't in the cage when we were there, but it's just there now, that's her dog.
Oh, she ran in. We didn't put her, she was,
We don't have eyes on your dog. Okay, that's fine. Thank you. Okay, it's just gonna be the bottom one that's gonna be locked, isn't it?
yeah, cause she was barking. So somebody stole my dog.
But again, like I told you, I can take a look. You said someone actually has to carry it downstairs?
Yeah, she don't know how to go, she must come back up. So how the hell did she get downstairs? Oh, this like a car patch.
No. You heard what I said? I said I understand it. I understand it. No, I know the power of pets. I do. And I wish I could give them to you right now. I can take you home right now if you want to.
I want somebody to cover my dog. And if, I called somebody to let my best friend, my name is Woody, yes, Woody. But she would have been barking. She would have been barking. And I wish I would let me go back there and everybody just go into the car so quick. And this shot blanked me. And now I touched my dog. I got that dog because I'm going through my mental health. Now you put me back in mental health.
But, and I'm sorry, and I don't wanna brush it off, because again, I do understand the power. No.
One, I know she's gonna use dog. I can't help it. You don't know that dog is, when I come down and don't sleep with me. When I'm not away.
I'm not gonna downplay how important these pets do help
Fuck
us.
my dog. And my dog is gone. And he did something, he killed somebody, my daughter's gone, my other daughter maybe.
You were telling me that y'all were arguing about 15 minutes before.
I don't know, we was arguing, like we argued about the simplest thing. All I know is he got on my nerves, she put her text saying, and we didn't go.
That's right, she was driving off her own. What time is that? If you, yeah,
What's up with it?
9:30, she said she's outside. At 9:28, she said she's on the way, and then exactly 10 minutes later, she said she's outside. So that's at 9:38. What happened?
One time I looked outside, and I guess I just looked, I didn't see nothing, because go back. Then I guess I talked, I don't know, let me just talk to it.
Because I'm a little confused on how they knew you were arguing.
She said, she heard it.
From outside? From inside her car?
That's what she thought. That's what we got talking about. She said she heard me.
So there must have been a phone call then. What made you come outside?
Yeah, she got it.
What time was that?
Yesterday, canceled, 9:28.
Yeah, that's what she said she was on the way. What made you come outside?
Yeah, I called her, but I know, I came outside, she was like, you know, and then she said, I heard y'all arguing. She was like, well, I was bringing back smaller, and I was like, well, no, I said, you know, I'm do whatever to protect my grandma. She was like, yeah. I was like, she was like, well, you okay, Mom? I was like, yeah, I'm just down here, sit down here. He wasn't saying anything. And then we looked at me, he was like, you okay? And he got in the car. And my daughter was like this, like she was actually, no, she told me to come with her. And I said, no, I'm good. He got the car and he said, well, what he said, and I was like, no, I'm good. And then my daughter told me too, like, but she didn't get out the car, she sat in the car. Well, there's something that you just, in the house. But we have to do. I said, I see it in the house. He was on the couch. He said, what's up, you been going crazy? He got up, and I was like, Corey, I was like, just go. I was like, it's okay, just go. Corey had his gun. He didn't have his gun. That's what I'm saying. I'm with him. Jason, you with him. He got that. So he looked like he was scared. Jason, so I got Corey out somehow. I don't know. All I know, that door, he shot through the door.
You know how you do this gesture when you mention Corey's gun? So did you see it on his side? It wasn't necessarily in his hand, but
I said, okay. Then I think that's why I was swooped down.
so you shut the door. How much time went by between you shutting the door?
Not even 10, almost 5 minutes. I was like, boom, boom, boom. And she was like over my head.
So it was as if he was shooting towards you. Well, hold on. No, that's different. Okay, so
So the door was like that.
let's just say you're.
And I was like, kitchen, on the kitchen, right here.
Yeah, let's pretend you're Jason and I'm you, okay?
He came from right here. He was somewhere right in my head, man.
Uh-huh.
All I know, and I was like, what the fuck, and that's not. So that's why I'm so on, like, when I say about my daughter, because when he did that, I knew that boy couldn't have got down that steps quick because it was too quick for me.
Okay, so it wasn't necessarily 5 minutes. As soon as you shut it, he shoots.
It seemed like, yeah, but where he came from, because you gotta understand, like, I was a daughter. So whatever he could be doing, whatever he did, I'm back.
Are you saying the gun?
Yeah.
Okay. Yeah, I'm just making, I just gotta make plain, yeah. But you've never known him to have one?
I personally, that man has never shot at me, put no gun, did none of that. We done argued, we done, like, I never been physically, none of that.
But did you know he had a gun?
No.
Out of all the years y'all been together, you've never known?
I mean, I probably, yeah, like early in the years, but like, for one, I'll be honest with you. He know I don't play that from my grandson either, because that's the thing that we do. Like my grandson, he don't argue, I don't do that around him. And if we do, we be in his room sleep or whatever, we don't do that. So that's what I'm telling you, like, all this is, you don't understand that I'm hurt for him too. So I'm like, why? You don't need to fuck your whole life.
Oh, yeah.
You get what I'm saying?
Oh, yeah.
So you don't understand where I'm coming from. I'm like, wow, like, I don't even know how to explain it.
Now, again, your grandson wasn't there. Your granddaughter was there, but she was.
No, she wasn't in my house. She was in there, she was coming to bring her.
Right, she was sleeping,
In that car.
can you tell me in that red car, who was sitting behind the driver? Do you know?
My daughter was behind him. He was in the passenger seat. My daughter was driving.
Your daughter was driving,
He was in the passenger seat, and the baby was behind him.
behind the
Because I looked at her and I remember she.
I only asked because the door behind the driver's door was open. You know why? I guess it's your daughter's, is it your daughter's car, the red car?
That's his car.
Okay, so his car, like that car, the door behind the driver's seat was slightly open. I was just wondering who came from there, or when you went downstairs, did you?
Maybe I opened it, or I won't say that, but
It's no big deal, I'm just
no,
wondering.
I wanna be as accurate as I can be. Maybe I did, because my first thing was to get her, to get her outside.
Today,
Yeah, because that's where she's
the
coming.
purpose, yeah, okay.
And my daughter tell you, she never experienced like these, like, my granddaughter, my grandkids have been, they love them together. Yeah, Jason. And so that's why it's kind of still like, wow, like, I think he was scared.
Is Corey, the girl, your granddaughter who was gonna get dropped off, is Corey her father? Is Corey any of your guys, your grandchildren? How long Corey and your daughter been together?
I wanna say from the end of last year,
So now you've been 6 months.
but I like her.
I'm just saying, what I do, he cared enough to walk up. I mean, and I'm not saying this for you to feel like it's, this is completely 110% Jason's fault. But, I mean, for the characteristics of what you're telling me and from what your daughter's telling me, he's got a decent dude. And I'm sorry, I see this crew out there acting real crazy on the scene, like, people don't do that for just anybody, you know what I'm saying? And I empathize with everybody's emotions out there, I can't even be mad, honestly.
Yeah, that's what I
I
told
can't be
her.
mad.
When I was talking to my friend on the phone, she was like, they acting crazy. I was like, I was,
How else would you support that, honestly? Yeah, I mean,
but I was scared to make it in because, and what I was there with my daughter for is because when they talk about what he had on, don't act right now, that is not what we trying to do. Like, you know what I'm saying? So it made me bad because now they looking at me and then they start running towards, that's when that man threw me in the car. Because you don't do that, now you point the finger at me like I did, and you know damn well I did.
that is frustrating, but just don't count on that, that's all I can say. And you're right.
Nah, I'm not going, no, because I understand.
All right, cool.
I understand everybody.
Yeah, and this is the day, I still gotta call. That's what I'm about to do next, call this, that family. And I don't mind first taking you home if you want, but could you just wait a little bit, and give it a little time? Meanwhile, I mean, we can get you to a more comfortable space, if you want to use the bathroom, I can get you a snack, I can get you something to eat, like, tell me what you need right now.
Sure,
Let me sit here with that, if you don't mind.
you have to tell me what the. Jay. Man, what the fuck, man? No, even if it wasn't even for him to come in and check you, for one, now they was telling you to come, you know what I'm saying, outside, they heard us argue. Which I be telling you to shut, cause you be loud as hell. Well, he's gone. You know that, right? Well, Jay, what are you gonna do? No, someone's about to have to be, the family was trying to get at me. No family came over there, bro. So you left me with all this bullshit, my dog gone, the boy gone, my daughter hate me, my other daughter gone, And like, what the fuck? Like, I don't even know where to go. I can't even go home. And I'm about to lose my grandson, my apartment, everything, bro. What the hell, man? What the fuck? How the fuck I should have kept, man? Nothing. Dre, that boy walked out.
Listen, Jason. Jason. So you're saying that he pulled out a gun, right? Okay. Listen, we found a gun inside of Miss Stuckey's apartment. Would that be the gun that was used against Corey? Okay. Do you remember how many? Well, we can talk about that later. So you tell me what happened. Tell me what happened. And mhm. Mhm. Oh, oh. Do you know, you have no idea why he came to the apartment in the first place? And you said some folks was knocking on the door? What they want? So what happened after he pulled out his gun? Mhm. So when you shot at him, you could still see him. He was still inside the apartment when you shot him. Mhm. You talking about before he came in? Mhm. Was everything cool? Was everything cool before they even showed up? I got you. So, Jake, are you gonna come in? Are you gonna come in and make this statement like official or like, what's your decisions here? But the problem with that, just what you're saying is what caused him to come isn't what ultimately made him cost his life. That's not what caused him to come. I don't think that's what caused his life. It was just some gunshots, and I'm trying to understand why that happened. I got, I everything was fine. I mean, you had some people knocking on the door looking for some weed, but that don't got nothing to do with it, right? That don't got nothing to do with it. Okay, so where are you now, Jason? Is it far from downtown? Okay, what time you wanna come in tomorrow?
What's my dog?
Do you know about that? Her dog? I'm sorry, we're gonna look back on that one. With 2 p.m. tomorrow, is that before or after your shift? Okay, so you're gonna get off, so, okay, that's. Tell me what it looks like? Like, is it, like a rifle, pistol, and extended play? Could you tell if it was a Glock or anything like that? Gotcha, okay. What's a good phone number? Is this the 470274? Is that you? 274. Mhm. And no, wait a minute, let me get clarity on that. Like you literally never saw him before.
Ray, keep it real, you know now I'm bringing Gillette to come see me, don't act like I called for it, I don't even talk for it, me and you both don't know for it. Because, you know why, now I say go in the house, and I said I want, she heard me and you arguing, Dre. She heard me and you arguing outside. Dre, Nana told me that she heard us arguing, she was about to take Jalea back. Why you think I brought Jalea back into the house? You came up there. You came to literally walk me. So I didn't know that was gonna happen. You said what? Okay, well, Dre, first of all, I didn't know that. But second of all, you know that I was dating my grandmother. Let me see this,
Jason, the weapon that was used, where did you leave it in the apartment?
and then you left that shit for me to go down for. Like, what they would have said I did it.
Wait a minute, let me clarify. Jason, can you hear me? We're not saying, we are not assuming that she's a shooter. We're not gonna come up with scenarios like that. We're gonna stick to the facts, okay? Let's just stick to the facts. Now, where do you think you left it? What kind of gun did you have? Okay. How long you had it now? Okay. 3 months. Black can call it Ruger. Is it that man Ruger? That's cool. It's cool, don't worry, we'll figure that out. But look, are you able to take a phone number? Or I can text you. I'll text you. I do understand. I do understand. I said I do understand. I'm texting you right now my name, so you can have my information. Let me know if you got it. Where you work at? Okay, but you're gonna be off before 2 to be here at 2. You know where we are? You got my text? There's, I get what you're saying. No, yeah, I understand. I get what you're saying. I do. I get what you're saying, and it just sounds like your manhood was tried. You ain't like it. He said it's going.
All right, we need to stop here. Thank you. We're gonna need to break for lunch right now. We will come back after lunch and pick up exactly where we left off. It's been paused. Please, during your lunch break, don't talk about the case. It's okay to eat as a large group, small group, however you want to do it. But it's not appropriate to have deliberations in subgroups. We need all 12 of you in the jury room to do that. Your colleagues, the alternates, can join you for lunch. I'm going to let them know you're breaking for lunch right now. They're in a different jury room right over there. They can interact with you as well because you can't talk about the case during lunch. So they may want to tag along. But let's try to be back here by 1 o'clock, please, so we can pick back up with the video. Any questions about that? All right. Thank you, everyone.
All right, sure.
All right, Ms. Rivers, are you ready? Let's go back on the record in State versus Hall. Mr. Hall is in court with his lawyer. We've got all three prosecutors here. I received several notes. The first says, please replay from 221 to 224 on the interview with Ms. Stuckey twice. I don't know where that is, but if you could get it as close to 221, it's okay to be a little before it, just not after it, and they want to hear it twice. That's the easy one. Dear Judge, questions. 1, if I suspect one juror has been partial and continues to be by stretching the definition of self-defense beyond the legal definition, what options do we have? 2, if the jurors who are outliers went to lunch together yesterday, is it okay to ask them if they discussed the case at that lunch? 3, may we have a refresher on the legal definition of self-defense, please? In particular, how to define reasonable. 4, in what scenario do we agree that the jury is hung and cannot reach a conclusion? And this is from, it just says foreman, so not a name, but a role. And it is a different handwriting than whoever wants to see those 3 or 4 minutes twice. So the first thing we're going to do is finish watching the Stuckey video. We'll replay that segment twice. We'll get the rest of the way through. We still have to play the 4 ring videos. We're going to do that as well. And then my suggestion is that I instruct the jury again on justification, all the pieces of justification, and not work through these others yet. It's too soon to talk about the jury being hung. In other words, engage them. And I don't take any of these notes to be that jurors aren't deliberating, they're not agreeing, and some are taking a more elastic perspective of what reasonable is. But I don't know that it's our role to get in the middle of that. So that's my proposal. Maybe what I would do is before they watch any more of the video, re-instruct them on self-defense, justification, and the related propositions, excessive force, et cetera. And then we would watch the rest of the Stuckey video with that one part played twice, and then the ring camera videos. Mr. Abate, any issue with that approach?
No, they have copies of the chart, or
They do.
I couldn't remember.
In fact, they have 7, the original plus 6. Ms. Feely, any objection to handling it that way?
No.
Okay. What is 221 to 24 part of the phone call where we hear Mr. Hall, or is it before that?
It's part of that.
Okay, so it's just rewinding a little ways.
I got it. I got it at 221:06. That's the question.
That's fine. Okay, let me,
What were the, so I know when to go back, what were the times?
221 to 224. They want to hear that twice. I'm going to ask them if they really want to hear it twice. It's what the card says. And if once is enough, then what we'll say is we're not picking up where we left off, which was the end of the call. When the call got disconnected, we're actually rewinding a little ways, and we'll play it through. And if they say, no, we really meant twice when we wrote twice, then I guess when we get past 224, go back to 221-ish.
I'm gonna have to, as soon as the call ends, ask for 10 minutes to skip, so I'm gonna come back and ask.
Okay, sounds good. Let me. Okay, let's bring the jurors in. You collected all their electronic devices again, and are the alternates in their space? Okay, let's do it.
All right, the jury. Judge the President of the County Court.
Everyone have their Yetis or whatever, the tumblers? Good, okay. Welcome back, ladies and gentlemen. Thank you for accommodating my need to handle these 3 meetings. They're done. You were busy, you ate, and you sent me some questions. One of the requests was to replay from 221 to 224 on the interview with Ms. Stuckey. And Mr. Hiles has gotten it queued up to about 221. We can't do it precisely. It says, please replay that segment, and it says twice. Is that in fact the request? We'll replay it once, but then again replay it. Okay, we'll do that. So when we get to 224-ish, or whenever it is you all have heard the full part of what you wanted to hear, then let us know so Mr. Hiles can get back to the 221 again. And then we'll play it the rest of the way through. We didn't finish the Stuckey video. We're close, but there's more after that phone call with Mr. Hall came to a close. And that's where we paused, was that phone call ended, the call was disconnected, whatever happened. And then I said, that's when we need to break. So we need to finish that. And then we need to watch, at your request, unless you say you don't want to watch anymore, the 4 Ring camera videos. Before we do that, there was another set of questions that all connected in different ways to self-defense and what's meant by that. I'm going to read to you again. I know you have it there, but I'm going to read it to you anyway. The pertinent part of the jury charge that relates to self-defense. Justification is what it's called, but a form of justification is self-defense. So I'm going to read that to you. So you will have just heard it as you listen to whatever it is you want to hear played twice more, the rest of that call and the 4 Ring camera videos. And then I'm going to ask you to go back and keep discussing the case. So first, sometimes a defendant's use of force is legally justified and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury only when, 1, he reasonably believes that the use of such force is necessary, 2, to prevent death or serious bodily injury to himself. And there's also defensive habitation. Did you want to hear that again, or just the self-defense part? There's more I'm going to talk to you about, but I wasn't sure if it was the self-defense piece or also defensive habitation. I'll skip that part. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. A person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. However, a defendant is not justified in using excessive force while acting in self-defense. If you decide that the defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then the defendant's actions would not be justified. For the defendant's use of force in this case to be justified, number 1, the defendant must have believed that his use of force was necessary. Number 2, that belief must have been reasonable. And that means that a reasonable person would also believe that the use of force was necessary. And finally, the defendant's reasonable belief must have been what prompted him to use that force. A defendant is not justified in using force against another person solely in revenge for something the other person did or said on a previous occasion, no matter how serious that past wrong may have been. If you find beyond a reasonable doubt that the defendant used force against the alleged victim for for the purpose of avenging this past wrong and not for the purpose of preventing imminent death or serious bodily injury, then you would be authorized to convict the defendant. Keep those words in mind. Mr. Hiles, if you could please start us. Again, we're watching the video of Ms. Stuckey's interview, which is exhibit. Any idea? I can look it up.
165.
Yes, states 167.
Boy gone, my daughter hate me, my other daughter's gone, and like, what the fuck? Like, I don't even know where to go. I can't even go home. And I'm about to lose my grandson, my property, everything, bro. What the hell, man? What the fuck? How the fuck I should have kept, man? Nothing, right? That boy walked out.
Jason. Jason. So you're saying that he pulled out a gun, right? Okay. Listen, we found a gun inside of Miss Stuckey's apartment. Would that be the gun that was used against Corey? Okay. Do you remember how many? Well, we can talk about that later. So you tell me what happened. Tell me what happened. Mhm. Mhm. Oh, oh. Do you know, you have no idea why he came to the apartment in the first place? And you said some folks was knocking on the door? What they want? So what happened after he pulled out his gun? Mhm. So when you shot at him, you could still see him, he was still inside the apartment when you shot him?
I heard what I needed to do in case anyone else wanted to hear it.
No need to play it again? We're good?
Okay, so I'm gonna go back to where we were gonna start.
So you're going to the end of the phone call. I guess there's a break after the end of the phone call was one of the areas we were leapfrogging?
Yes.
Great. You get us to where we need to be, please, Mr. Haas.
Yeah, right.
Since we was able to talk to Jason, I kind of just want to ask, well, what was this, you know, where is he, where he lying?
Literally, not, no, he did do, when you said, he did come down and did the nuts, because he was sitting on top, like I told you, you know, he said, on top. And he was kind of rushing up a little bit, so that's why I said, I don't know if he was scared.
You told me that you saw the gun. Did you see it on his hip, in his hands, like, where did you see
Like,
it?
it's, I don't know, I seen it, I just don't know if he just showed it or what, but I seen it, but that's when, you know, quick reaction is, yeah, let's go. So, that's,
Did he ever point a gun at your boyfriend? No. Did he ever even, you know, like, separate the gun from his
I
body?
think he did.
But he didn't point it at your boyfriend?
Doing, oh, shoot.
Right, point it at him.
I didn't really see that.
Any threats, what was said?
He was like, what's up? Like, he came there, he was on some.
Okay,
I'm
but
coming
he
in to
made it
check.
out the door.
Ain't nothing, no.
You shut the door. He's out your
The
door,
door was shut.
and he's out of your apartment.
But I can't tell you what Jason's, like, that's what I'm trying to tell you. I can't tell you. When he was leaving out the door, I don't know what Jason said, all I know is the gun shooting. That's what I'm trying to tell you.
And
So,
where were you standing when he was shooting?
I was by where the where the couch at, right
The
here.
red couch?
Yeah, you know, like you come that little hallway, front, you come in like the door that way. I was standing there, you know, with the microwave. I wish I could just show you.
I remember it.
Matter of fact,
Matter of fact, nah, I gotta tell you. Let me see.
It was more like the gunshots was on me. So I was standing right there. Literally, to me, I was scared my damn self.
Just point where you were standing when you see it. And where was your boyfriend standing when you shoot?
It was like over my head. I can't tell you what he was just doing, but I was like kind of like that. Man, it was
And he had me somewhere further into
like right here. I want to say this right here. It was just like this pile, like you know, and like that's what it was. It was fucking alarming, like. So it wasn't like he pulled it out in front of me, did like that. It was some way he had it and all that the gunshot. But the gunshot was right here. So he was standing, he had to be right here. My house is like this.
It is, but all right, so let's talk about what's clear. Let's talk about what we know. You shut the door, you got him out. You shut the door, you weren't standing at the door when he was shooting. So right? So you shut the door.
I was coming back. I was standing by the thing, whatever. All I know is all I heard is talk about. And I wasn't, like I told you, I was still standing with my stove.
Yeah.
All that, I'm still right there. All right. So he had been right here because the shit was really by my ear. I remember that. That shit was by my ear. I never forget that. Literally, I was thinking, to me, I think he's gonna kill me. That's how close.
Running doesn't work. Oh, yeah. This one needs to be.
That's all we watch.
All right. Let's pivot to the ring videos. Are you able to make that happen? If you just play them in chronological order, please. Do you need that replayed? Nope.
Is that from downstairs? They came there to put a pistol on me, bro. Is that from downstairs? No, he just came there to put a pistol on me. What is that? Are you good, bro? Yo, please, you never put a pistol on me, bro.
Does anyone need any of those four replayed? Okay, I'm going to ask you all to return to the jury room and resume your deliberations. And let me know if there's anything else we can do to assist with those. Thank you.
All right, sir.
They worked very smoothly. Thank you. We need to invest in those in the courtrooms. Mr. Abate, anything else from the state before we go back into waiting mode? Ms. Feely?
No, Your Honor.
Okay, Mr. Hall, we'll bring you out when they've got more questions, concerns, whatever they've got. I will make both the note card, which requested to replay that one segment, and the 4 questions from the 4-person part of the record. Thank you. Unrelated to this case. Go for it. Hold on one second. Let me mute the court.